Okay, everyone, it's 6:30, so I've turned on the stream. So if it's all right with you all, I'm ready to commence. First of all, I'd like to thank you all, the lawyers from Bennett+Co, as well as our competitors, for coming in this evening. I'd also like to thank everyone listening in at home, YouTube, or wherever you're connecting tonight. One moment, please. Sorry. So tonight the competition will be the Bennett+Co MSLS Senior Mooting Grand Final. The competitors have worked very hard for several weeks analysing several areas of law, which they are now expected to present in a simulated courtroom situation. We're joined tonight by our sponsors, Bennett+Co, who we'd like to thank very much for sponsoring this competition. It's a brilliant way to help out and help the community at Murdoch University. Judging for us tonight are Martin Bennett and Nathan Ebbs from Bennett+Co. Nathan was appointed Bennett+Co's managing principal in October 2016 and practices in the commercial litigation and dispute resolution section of the firm. He has a broad experience running commercial litigation for public and private companies, partnerships, trusts and individuals, and has appeared as an instructing solicitor and counsel in many high-profile cases. Martin was admitted in 1978 with a reputation as one of Perth's leading and most fearless advocates. He has built a career of considerable achievement across all areas of civil and commercial litigation and regulation. He has several high-profile successes in the High Court, Federal Court, Western Australian Supreme and District Courts. He's a brilliant strategic thinker and of Western Australia's most eminent counsel. Again, thank you very much, Anthony, for joining us. To those viewing at home, if you're confused at any point, the question is available at comps.msls.asn.au. That's the competence portal and can also be accessed via our main website. Unless anyone joining me in the call has any questions, I'm happy to start us off. No? Okay, Mark and Nathan, it's over to you.
Call the matter. Appeal number 120, Milanovic and Constable. Yes, Ms. Ogle.
May it please the court. My name is Megan Ogle, and I appear as counsel for the appellant, Milan Milanovic, together with my learned junior, Madison Colangelo.
Thank you, Ms. Ogle. Mr. Moray.
May it please the court. My name is Maury, and I appear for the respondent, Mr. John Constable, along with my learned junior, Ms. Tucker.
Thank you, Mr. Moray. Yes, Ms. Ogle.
Would your honours like a brief summary of the facts before we begin?
You should assume, Ms. Ogle, that we're familiar with the facts of the first instance judgment, and we prefer it if you went straight to your argument. You should assume that we've had the opportunity to read each counsel's written submissions. So please develop those as you see appropriate.
Yes, Your Honour. This dispute gives rise to two main points of contention. The first is whether or not there was a valid contract for the sale of Hollander, and the second is whether or not there was a valid contract for the sale of Studenica. Our contention is that both contracts are valid and therefore enforceable, and we have three submissions in support. The first is that the contract for the sale of Hollander is valid because the common mistake was not of a fundamental nature. The second is that the contract for the sale of Hollander is valid because there has been no unconscionability. And the third is that the contract for the sale of Studenica is valid via operation of the postal acceptance rule. Submissions 1 and 2 concern ground A of the appeal and are independent of each other, whereas submission 3 concerns ground A of the cross appeal. Moving now to the first submission, which is that the Hollander contract is valid because the common mistake was not of a fundamental nature. In order for a contract to be voidable as a result of common mistake in equity, 5 elements must be satisfied. And these elements have been listed in the case of Sol and Butcher, 1950, Volume 1 in the King's Bench Division, starting page 671, pages 692 to 693. Your Honours, may I please dispense with formal citations?
Please.
These elements are: 1, there was a common misapprehension between the parties, that is, for common mistake. 2nd, that the misapprehension was fundamental in nature. 3rd, that the party seeking to have the contract voided must not be at fault. 4, that it is unconscionable to allow the other party to benefit as a result of the mistake. And 5th, there must be no possibility of any third party's rights being unjustly prejudiced. Now, our contention here lies with the 2nd element, and we submit that the mistake common to both parties, here being that the Hollander replica was the original painting, is not fundamental in nature.
I worried about that when I read your submissions, so, but before we get to that, was there a common misapprehension by the parties? Both were aware of the subject matter of the proposed contract, the painting. They correctly described it. There was an offer and acceptance on your cases dealt with, and I think it's found at first instance. And the only misapprehension was as to the quality of what they were perceiving. Is that a misapprehension as to quality? Is that a sufficient basis, do you say, to ground a mistaken equity?
Your Honour, we submit that the only common misapprehension in this case was that both parties believed that the painting was the original. So that is the misapprehension, because as we know, the painting was in fact the replica of the Hollander.
I should make a claim. Do we assume that the 3 Theodosius experts' view was accepted by His Honour at first instance, that Hollander is therefore a copy? The mere fact that they were referred to in the otherwise reputable magazine Church Art doesn't itself admit as proof of that proposition, but we take it that that was a finding of fact that's not challenged on appeal.
Yes, we take that as a finding of fact, Your Honour.
Thank you. So going back to that, was there a misapprehension as to the subject matter of the contract, or was there merely a mistake as to the quality of what they were contracting?
It was a misapprehension as to the subject matter of the contract, Your Honour. In the case of Great Peace Shipping, it was held, in order for a mistake to be fundamental in nature, it must create a fundamental difference between what had been agreed to and what was to actually happen. In other words, as a result of the common mistake, performance of the contract must become something essentially or materially different to what the parties had initially contemplated. Now, in the Great Peace Shipping case, salvagers agreed to hire a rescue ship for 5 days and then reneged on their agreement. And in this case, the common mistake between the parties, that being the owner of the rescue ship and the salvaging company, was that a damaged ship in the ocean was 35 miles away from the rescue ship in question. In actual fact, this damaged ship was 410 miles away, and as such, it would take significantly longer to get to. Now, in this case, the court held that despite the damaged ship being significantly further away than had been previously thought, the salvagers still could have provided the rescue ship that had been the essence of the agreement. They still could have saved the lives of the people on that damaged ship, and as such, the contract was not void. Now, relating to our present case, despite the Hollander being a replica painting, the essence of the agreement can still be achieved here, namely that the appellant would sell the respondent a valuable and famous religious artwork for $800,000. And we can...
How could a copy be a valuable religious artwork? You can get a copy, a tea-towel version of the Mona Lisa. Is that worth the same as the actual original?
No, Your Honour, not in that case, but the facts in this case lead us to that conclusion. We can see sustained references in Justice Shaw's factual summary to the value of the artworks. At paragraph 9, we are told that the Hollander replica is of such high quality that it is practically indistinguishable from the original copy. We acknowledged that they eventually were distinguished by the free acknowledged theodicist experts. However, we can reasonably infer that the majority of the general public and even the majority of art enthusiasts do not have this kind of incredibly specific niche knowledge. Furthermore,
Would be a relevant matter though, if at any stage the gallery sought to resell, they'd be obliged to disclose that it wasn't an original. And would you concede, for the purpose of this appeal, that that would have an adverse effect on value?
Your Honour, we acknowledge that, yes, the original copy may be of more value than the replica. However, that does not diminish the fact that the replica itself is of extremely high value. We are told at paragraph 15 of Justice Shaw's fact that the Hollander replica had been on loan for 2 years to the Murdoch Vice Chancellor, who had a keen interest in art. Due to the fact that we can see that the Hollander has been loaned out and is being displayed by art enthusiasts, we can see that the replica is in essence the same as the original because it is being treated the same. It is being loaned out and displayed and treated like it has value of the original, and therefore we submit that it is essentially and materially the same as the original.
But Ms. Ogle, that, from my understanding, is because of something the university was labouring under a misapprehension about what they had to hang on their wall, wasn't it? If someone had said to them, to take my the brother's example, if they were to take the work and knew it not to be an original, do you think the interest level would have been the same? So I don't know that you can necessarily draw a conclusion that because a replica is a good replica or a replica that can't be discerned from anyone but an expert to be different, that it then has that inherent value based on that. And I think that's put in your written submissions, and I think it's paragraph 1.6, the fact that it's interstitial. I don't see a lot of turns on that. So for the fact that when the parties were contracting, no one could tell that it was a replica rather than the original from its appearance.
The contracting parties couldn't tell.
The contracting parties, correct. You needed an expert to actually discern the difference. But I don't know that one gets to value based on that.
Again, we acknowledge that that may potentially be the case and that people's actions may have changed had they known for certain that this painting was a replica. However, we maintain that due to the extremely high quality of the replicas and the sheer fame of these paintings, as we can see in paragraph 8, these paintings are 2 of Theodosius's most famous works, purely because these replicas have this level of these are so highly esteemed in the artistic community. For that reason, we submit that these replicas are extremely valuable.
Yeah. That moves into your second argument, doesn't it, Ms. Ogle, that behind the proposition that you advance in paragraph 2.3 of your written submissions, is it the case that because there's such high quality, such a high quality forgery of the original art piece, that no party's been unfairly advantaged nor disadvantaged? Is that right? Is that what lies behind that proposition?
Our second submission relates to the 4th element of the test for common mistake. That is, we submit that it is not unconscionable to allow the appellant to benefit as a result of the mistake. And we take an unconscionable outcome to mean one which is shockingly unfair or unjust, that is overwhelmingly one-sided in favour of one party. And we would refer to the case of Taylor and Johnson. Now, in this case, Taylor took deliberate advantage of Johnson by allowing her to continue mistakenly that she was going to be paid $15,000 per acre of land, when in reality, she was getting paid $15,000 for 10 acres of land. Now, we can distinguish this in the present case because there will be no unconscionable outcome such as this. The respondent will still be paying a certain amount of money for a painting of extremely high value. There has been no deliberate conduct as such to mislead or take advantage on the part of the appellant.
That's the important point, isn't it, that you would make? Is it not, Ms. Ogle, that there's no act on the part of the respondent your client, the appellant, to mislead Mr. Constable? He was operating under the same innocent misapprehension. Is that right? Distinguishing the position of Taylor in the Taylor and Johnson case, where Taylor was found to have knowingly acted on the basis that Mrs. Johnson was labouring under the misapprehension that you mentioned a moment ago.
The point about deliberate conduct was simply an aside point, Your Honours. Our core submission is that both parties laboured under the same common misapprehension. Our submission in this regard more relates to the fact that no unconscionable outcome will result. No party has been unfairly advantaged or disadvantaged in these circumstances.
Ms. Ogle, do you take anything from the point you raised the unconscionability argument, but based on the facts, we have a circumstance where the painting is going to be restored to the family. So in essence, what's happened is a copy's been sold for $800,000, and the original is going to be restored to the family. So in effect, shouldn't equity intervene to stop that circumstance?
We have not been informed as to what the appellant will or will not do once or if he regains possession of the original copy of the Hollander, so we cannot speak to that intention. However, we do not think that equity should step in this regard because, again, we do not know if the appellant will seek to sell the original. We do not know if he will simply, say, hang it up on his wall. In fact, we are actually told in the facts that the appellant has very little interest in art. So I doubt, we cannot say for certain what the appellant would do with the painting, and as such, we cannot reach a conclusive conclusion on this point. Further, in the case of Commonwealth Disposal Commission, the court held that a contract between McRae, a tenderer, and the Commonwealth Commission was not voidable. And this was because the common mistake in that instance being that there was an oil tanker and a reef in a certain location led to an unconscionable outcome, as McRae had incurred great losses from outfitting and mounting the tender expedition simply by carrying out what they were contracted to do. Again, in this case, there is no such loss or unfairness. It is not as if the respondent will pay out the money and receive, as you say, the Mona Lisa on a tea towel or even nothing in return. As such,
McRae's case, the tender was led by the government of the Commonwealth to salvage an oil tanker on a reef, and there was no oil tanker on the reef at all. There was
yes.
absence. So here, I don't take it that the reference you make in footnote 6 on your footnotes, McRae's I don't see as a authority for the proposition that you draw from that in paragraph 2.2. McRae's case is a breach on the part of the Commonwealth of an implied representation that there was something to salvage. At least that was part of the reasoning of their honours in the High Court. Do you accept that?
We acknowledge that the cases are different in the sense that, yes, the oil tanker was never there to begin with. However, we can still take the principles discussed about unconscionability and unfairly advantaging or disadvantage a particular party. In the interest of time, I will now move to my third submission, which is that the contract for the sale of Studenica is valid via operation of the postal acceptance rule. We submit that the respondent's email on the 3rd of April 2018 constitutes valid acceptance of the appellant's offer to sell Studenica by operation of the postal acceptance rule. The postal rule stipulates that where the parties contemplate acceptance by mail, acceptance will occur as soon as the letter is properly posted. The contention here is whether or not the postal rule applies to email communications. We submit that in these circumstances it does, and that the respondent's revocation email on the 4th of April is inoperative. And we can look to the case of Brinkybon. Now, in this case, a contract was created through electronic acceptance. And the court said,
Specifically a telex from Vienna. So that an telex is an instantaneous communication, isn't it?
yes, Your Honour.
Do you draw a distinction between that and an email? Or how do you equate an email to a telex?
We acknowledge that many consider emails to be a form of non-instantaneous communication, whereas a telex is a form of instantaneous communication. However, what we can take from this case is that courts have held that the postal rule can apply to electronic communications. Further, it can be reasonably inferred that the appellant contemplated that his offer might be accepted by email. We can infer this given that this took place in 2018 and from the fact that the respondent has both the appellant's personal and business email. Now, in their written submissions, the respondent relies on the case of Olive Isle. And we acknowledge that in Olive Isle, it was said briefly in obiter that where a contract is accepted via email, the contract is created when the email is received. However, the law remains unclear in this area, and Olive Isle only creates a general rule. It does not apply in every situation.
There's 1 minute remaining.
Thank you. In the interests of public policy, we submit that this court should find the postal rule applies here due to the technological difficulties which are intrinsic to email. These are...
What do you mean by that? What is the policy that you urge to apply? Is it certainty in commercial dealings? Is it the fact that the recipient of the email can always say, I didn't read it, I didn't open it? It was opened by a 7-year-old son, and I wasn't the one who, so it wasn't drawn to my attention. Is that the point that you're making?
Yes, Your Honour. The technological difficulty we refer to is that prescribing with certainty the time that an email will be communicated to another party. And various choices, including the time of receipt, the address's internet service provider, the address's computer, or the time the address reads the email, indicate all of these differences.
Apologies, time is up.
Your Honours, may I please request an extra 60 seconds to conclude? Therefore, we submit that application of the postal rule would eliminate these issues by making it very clear that acceptance takes place when an email is sent, and it does not allow for contention as to when an email may have been received. On the basis of the above submissions, counsel for the appellant respectfully requests that this court allow the appeal, dismiss the cross appeal, and find that valid contracts exist for the sale of both the Hollander and the Studenica. May it please the court.
Thank you, sir. Just give us a moment, please, Mr. Moran. Moray, please.
May it please the court. The respondent submits that the learned trial judge did not err in regards to the appeal and did err in law in regards to the counterclaim. The respondent supports this by way of two submissions. Firstly, the learned trial judge did not err in law in finding the contract was voidable by reason of a common mistake. And secondly, the learned trial judge erred in law in finding that the postal acceptance rule applies to email communications. Turning to my first submission. On this ground, we agree with the law as presented by my learned friend in respect to the 5 elements from Sol and Butcher. We also note that the only 2 elements that are in contention are that the mistake was of a fundamental nature and that the contract for sale is unconscionable. These form the 2 propositions in support of this submission. Turning to my first proposition.
Perhaps you could deal with the point that I raised with Ms. Ogle, Mr. Moray. If 2 parties stand in front of a painting and say, I want to buy that painting and I'm happy, the other one says I'm happy to sell it. They're talking about an object which they both see, recognise and describe. Their only mistake is a mistake as to quality. Now, a mistake overperforming from their honours in Taylor and Johnson would suggest that that's a quality matter is a matter of their mistake. Otherwise, wouldn't you have the uncertainty of you stand in front of a car and say, I want to buy it, chap says I want to sell it, and it's got some differential problem. And I say, well, it's not of the quality that I thought, so I can rescind in equity. How do you deal with, so I'd like you to address the quality argument as well as the 2 that your friend Ms. Ogle relies on, because that's a worry to me.
Your Honour, this actually goes to my 2 propositions, and I have 2 points in response. So firstly, I would like to draw the court's attention to paragraph 16 of the agreed facts.
Yes.
This states that the agreed terms of the contract was that Milan and Constable signed a contract for the sale of the Hollander for $800,000 with payment and delivery to take place on the 6th of April 2018. The contract did not say that the parties agreed to buy any ordinary valuable religious artwork. It specifically names the Hollander painting. In fact, the painting was a near replica, but not the Hollander itself. Therefore, the mistake goes to the...
Are you not taking paragraph 16 out of context? Because it's to be read in the context of 13 to 16. And what's plainly the fact is that Hollander is one of the 2 paintings that have been discussed since approximately 1949, 1950, when the appellant's father, Stephen, met Joseph Constable.
Your Honour, this goes to my second proposition in answer to your question.
I'll just address the first proposition, see how that goes.
Apologies, I didn't hear that, Your Honour.
Just if you could address the first, I take your proposition that you draw from paragraph 16 is that if you sign a contract for the sale of Hollander, you're not signing a contract for the sale of a copy of Hollander. Is that the submission you make?
Yes, that is the submission I make, Your Honour.
But I think the point I was making to you was that there appears to be a taking that as a statement of fact out of context, because it's plain from the facts in 15. In early March, the 2 men have been discussing the possible sale of the paintings. And these are the paintings that the respondent, your client's father, I think, Joseph, had been discussing with the appellant's father, Stefan, since 1949.
Your Honour, we submit that both parties were operating under the assumption that that painting in question was the Hollander itself, and this is why the contract specifies that the purchase is for the Hollander.
I accept, though, it's open on the findings of fact that both parties innocently believed Hollander to be the original. Yes, please proceed.
And in regards to the second response to your question, Your Honours, as my learned friend has contended that the fact that the replica is of a high quality means that the contract can in essence be performed. Your Honours, the true value in a piece of artwork is very rarely tied up to its aesthetic value. For the purposes of art collectors, such as the respondent, it is the history of the piece that makes a piece attractive to purchase. In this instance, the history of the respondent that the respondent was interested in, rather, is that this painting is one of the most famous works by the monk Theodosius. And this history is a lie. The respondent should not be bound to purchase something that is of no value to him because the history is not legitimate.
Well, I don't think there's a finding of fact that it's of no value. I think you're right to draw the court's attention to the proposition that we can take notice that a copy won't get worth as much as the original, but there's no finding of fact is there that the copy Hollander is valueless.
That is correct, Your Honour, but that still goes to my first proposition, that the quality, that the replica is not the Hollander itself.
Well, dealing with your second point, the second point you make is that as I understood it, that it's valueless. If you accept that it has some value, how do you modify your submission in that regard?
Your Honour, I do not submit that the painting itself is valueless, but it is that the painting is not valuable to the respondent because the respondent was interested in the history of this specific painting.
Your client ran an art gallery, I assume from that he sold paintings, is that right? It's in Rose Bay, New South Wales. But,
Apologies, I didn't catch that, Your Honour.
your client owns an art gallery. I take it that he sells art. Is that right? It's not value bound up in that?
That is correct. The respondent does own an art gallery. However, again, the respondent is also an art collector and is interested in purchasing this particular art because of its historical value rather than its aesthetic value. I cannot take this submission any further, Your Honour, so in the interest of time, I will move on. Turning to my second proposition, the contract for sale is unconscionable. We submit that the operation of the contract would overwhelmingly favour the appellant and therefore result in an unconscionable outcome. The contract price was for $800,000, attributable to the value of the Hollander as purchased alone. Even if this value is depreciated from the value of purchasing the paintings in a set, this is still a substantial amount of money to spend on a painting. It is an even more substantial amount to spend on a painting that is not an original painting. This demonstrates that the appellant would be unfairly advantaged by receiving this amount of money for selling something that is practically artificial and of no value to the respondent. Further, apologies, Your Honour.
No, you're relying again on the no value proposition. I thought you accepted that it had a value, but not the value.
We in this submission that we're supporting that the value is attributable to the value of the contract itself and to the respondent's value.
But again, the many an artist, in addition to painting major works, paints limited edition, so lithographs and the like. And so a lithograph will be one of a series of 4 or one of a series of 7. They all have a value, do they not?
That is correct, Your Honour, but this, apologies.
No, please continue.
That is correct, but this is not one of many paintings by this monk. It is one of the most famous paintings, and therefore it is of value to the respondent. He's not purchasing any ordinary painting by this monk.
Right. So your best point is that it's not a painting by the monk at all. It's a painting by someone in Belgrade.
That is also correct, Your Honour. And further, we agree that the appellant did not initially attempt to disadvantage the respondent by deliberately, as there was a common mistake. However, a continued insistence to sell the Hollander would be deliberately taking advantage of the mistake. And we know
That can't be right. I mean, a party who is innocent merely to deny that the revelation of the state entitles the party to rescission isn't deliberately taking advantage of somebody. To go back to Taylor and Johnson, once you know of the facts, you bring an action in this court or in one of our lower courts. There's no one's taking advantage of anyone. One's simply disagreeing as to the legal effect of it. So you can't rely on that, I think, as a bootstraps argument to say unconscionability lies in defending an action.
Your Honour, the case of Taylor and Johnson can be distinguished in this respect. Taylor and Johnson was for a sale of a contract of land that had already been actualised. It was already, in a sense, being performed. And in this matter, we have a contract that is outstanding. The passing of money has not occurred, and the passing of the painting has not occurred. Both parties are now aware that they were operating under a mistaken belief. If the appellant is to insist that the contract goes ahead, despite the fact that he is aware that this painting is not of value to the respondent, that is what is unconscionable in this matter. And we know that the appellant only sold the painting to overcome their own financial troubles. To insist on selling the painting despite not knowing it is genuine, now knowing it is genuine rather, would demonstrate that the appellant is seeking to address their own circumstances without considering the financial burden on the respondent.
I don't think motive for sale is relevant at all in itself, but my brother Debs might take this one.
You're resisted, aren't you, in your unconscionability argument, Mr. Moreau, by the value of the painting, aren't you? That's one of the key pillars to your argument, is in essence, if this was an $8 transaction, equity would not intervene, but your point is looking at the significant value that was attributed by the respondent. The circumstances are such that equity should intervene in this case. That's right, isn't it?
That is correct, Your Honour. The respondent is currently standing to spend $800,000 on something that he did not want in the current circumstances.
Well, he did want it. He tried to buy it for years, but when somebody in Belgrade said that it's not an original, he changed his mind. And his motive was to buy it and resell it potentially. So I don't think motive, as I said, it's important one way or the other. And I don't think on the facts as found by the later trial judge, this is a case of innocence on the part of both parties, is it not? Both parties laboured under the belief it was genuine. Stepper, given the paintings by his father, told they were the genuine ones. He told his son, Milan was the seller.
Your Honour, it is correct that both parties were mistaken at this point. Firstly, the case of Stolen Butt and Butcher was also a case in which both parties were operating under mistaken belief, and that was also found to be unconscionable and a common mistaken equity. And secondly, perhaps I misspoke, and I should rather say it is no longer something that he wishes to purchase, rather than he did not want to purchase. And that is what the unconscionability lies in.
I don't know if Solomon Butcher there was a mistake. It was a question whether the structural alterations and the improvement of a garage to a flat let in 1939 altered the nature of what was let. And what fell from Lord Denning, as often occurred, were observations of a general application, not necessarily picked up by Lord Justice Bucknell, and who gave the majority judgment in that regard. Would you accept that?
It is of a general observation. However, we submit that the principle can be applied. Your Honour,
Move to your second, please.
sorry, Your Honour?
Maybe you should, I was suggesting you move, Mr. Moray, to your second aspect of responding to the cross appeal.
Certainly. We rely on our written submissions for the remainder of this ground.
Thank you.
Turning to my second submission, the postal acceptance rule does not apply to email communications. We support this by way of two propositions. Firstly, the postal acceptance rule does not apply to email communications. And secondly, the instantaneous communications rule applies. We agree with my learned friend's submission on the definition of the postal acceptance rule. However, we note that courts have not extended the postal acceptance rule beyond post and facsimile. Because there needs to be mutuality in a contract, if a party does not know that contractual relations have arisen, then it cannot be bound to that contract. Regarding my learned...
Why did we have a postal rule in the first place? Can you give me your submission as to why did the court develop a postal acceptance rule? Was it not because it would be too easy to defeat a contract by the person receiving the acceptance to say, I didn't go to my mailbox for 4 days? And how could the other party, the acceptor, disprove that? It's a fact wholly within the knowledge of the party, the offeror to whom an acceptance is sent. Why is that not applicable in this modern day and age? If I send a telex to somebody, your friend relies on Brickbond. If I send a telex to somebody, I don't have to walk across to the telex machine. I can go there, I can be out of my office and go back to the telex machine, which I actually remember.
I don't.
But a telex machine, you could go back after leave on a Friday afternoon, come back on a Monday and find you had about 20 telexes. But that's maybe instantaneous receipt by the machine, but it's not instantaneous receipt by the person. The paradigm of acceptance is face-to-face. But the law developed as a policy, the extension of the postal rule, to ensure that contracts weren't put at naught by a party untruthfully saying, I never received the acceptance until after I had revoked my offer. Why shouldn't the court apply that same policy to emails?
Your Honour, this goes to the fact that emails are a form of instantaneous communication, which is different to posts. In that case, apologies.
They're not instantaneous at all. They've got to go through the sender's server to some ISP to the receiver's server, and then they get caught up in a filter. We live on a daily basis with emails getting caught up.
Your Honour, the Chief Justice Logan of the Federal Court in Olivale, after assessing a long line of authorities, found that emails are a form of instantaneous communication. And I quote, by analogy with cases concerning the position with what were or were treated as other forms of instantaneous communication, I consider that the contract was made when the acceptance was received, that is in Victoria.
Justice Logan's analysis is over. Your friends have you put to us that it's not over?
Your Honour, it has subsequently been upheld by other judges, such as by the New South Wales Supreme Court in Candy and GAO General. I note that this is not included in my written submissions, but we assert that this is true.
Oliver went on appeal to the full court, the federal court, and was regarded as a point not of significance by the full court, not commenting on. And so, did that not give weight to your friend's submission that it was an overt observation by His Honour? Valuable, nonetheless, and we would take it that the first instance judge in the federal court, out of comity, we should look to his reasons, but we're not bound by them as a superior court. We're an intermediate court of appeal, not bound by a first instance judge.
Your Honour, we find that it is still the correct state of law as asserted by other cases. I note that my time is close to expiring. Can I please request an extra minute to conclude my submissions?
2 minutes probably worthwhile. So I've interrupted you more than I interrupted.
Certainly, Your Honour. So the respondent submits that the time of apologies, Your Honour. The respondent submits that the postal acceptance rule does not apply to email communications. And I turn to my second proposition, that the instantaneous communication rules applies in these circumstances. The only issue that the common law had not resolved at this time was when the actual communication was to be measured by. And this has been clarified by the Electronic Communications Act. at section 14, subsection 1b, which I quote, "Your time of receipt of the electronic communication at another electronic address of the addressee is the time when both the electronic communication has become capable of being received by the addressee at that address. And secondly, the addressee has become aware that the electronic communication has been sent to that address."
You're referring to the Commonwealth Electronic Transactions Act of 1999, Section 14 of the Western Australian Electronic Transactions Act of 2011, both of which deal with the receipt of an electronic communication at sections 14. Is that the act to which you refer? Or either of
Your
them?
Honor, I refer to the Western Australian case.
Then we're talking about
Time has concluded.
a little bit more to explain. There was a question I'd like clarified. I just wanted to confirm you're referring to the Electronic Transactions Act of 2011.
In the Western Australian Electronic Communications Act of 2011, that is correct.
I think it's the Transactions Act.
Yes, that is correct.
Thank you. Sorry, complete your point. I just wanted to clarify the act you're referring to.
Certainly. So, Your Honor, the respondent's initial email sent on the 3rd of April accepting the offer of sale was not opened until the 5th of April. It did not give rise to a completed contract on the 3rd of April, as the acceptance was not actually communicated by reason of the operation of this section. By this time, the respondent had already withdrawn his acceptance by an email sent and received on the 4th of April. Therefore, the postal acceptance rule does not apply, and there was no valid contract between the parties for the sale of the Densia painting. On the above submissions, the respondent submits that the appeal should be dismissed and the counterclaim awarded. May it please the court.
Thank you. Ms. Wang, we'll just wait just a moment before we call them. I apologise. Thank you, Mr. Moore. Ms. Colangelo, can we hear from you, please?
May it please the court. I will be addressing the ground before the court concerning John Constable's rescission of the Highlander painting contract and his acceptance of the Studenica painting contract. The appellant submits first that John did not validly rescind the Highlander contract on the basis of a misrepresentation, and second, that John validly accepted the Studenica contract in a personal capacity, and extrinsic evidence is admissible to demonstrate this. Turning now to the first submission, a misrepresentation has not occurred here from allowing silence as the existence of a copy of the painting, so John had no basis to rescind the Highlander contract. This is supported by way of two propositions. First, Milan had no obligation to tell John about the copy, and second, that the silence of this fact did not induce and was not intended to induce John anyway. Only one of these propositions needs to be accepted by this court in order for the respondent's action in a misrepresentation to fail. Considering the first proposition now, silence cannot generally constitute a misrepresentation. According to the principle of caveat emptor, the buyer of goods must beware and look into what they are purchasing, while the seller is entitled to stay silent. Silence can only become a misrepresentation when there is a legal obligation to do so. As it was stated by Chief Justice Coburn in Smith and Hughes, mere silence with regard to a material fact which there is no legal obligation to divulge would not avoid a contract. Milan was under no legal obligation here to inform John that a copy of the Highlander painting had been made over 100 years ago. The respondent had argued at paragraph 1.4 of their submissions that John was reliant on Milan to tell him this fact, but the respondent has not provided evidence of a relationship that exists between the parties that would require Milan to do this. In the case of W. Bell and Lloyd, it was unanimously held that the party concealing certain facts was under no duty to disclose them. This case concerned the relationship between the buyer and seller, like our situation here. Justice Barton stated in that case that there is no pretense that there was anything more the relationship of intending buyer and seller. His Honour went on to state that this entitled each party prima facie to refrain from disclosing to the other any fact which he had discovered with his superior skill or knowledge. This sentiment was further expressed by Justice Arlax, who stated there was no position of trust or confidence, making it the duty of the plaintiffs to disclose to the defendant what they knew.
Ms. Glanjo, can I just interrupt you for one moment? Paragraphs 2 and 3 of your written submissions, don't they proceed on the basis that Milan had knowledge of the existence of the reproductions?
That who had knowledge, Your Honour?
And does that arise on these facts? On these facts, is there, other than a brief explanation that he had an understanding of the history of the paintings, do you accept that if he didn't have knowledge, paragraphs 2 and 3 of your written submissions are in essence redundant?
Is that if Milan had knowledge, Your Honour?
That he had no knowledge, that he had no knowledge of the existence of the reproductions?
Your Honour, this does rely on the fact that there were copies of the painting.
Relies on the fact that he did have knowledge of that fact, and in circumstances chose by his silence not to convey that in the transaction. But that doesn't seem to be supported on the facts in this case, does it? So in essence, you don't need that argument.
Your Honour, this argument is that with Milan's knowledge of the existence of the copies, he had no obligation to disclose those facts, and he was entitled to remain silent.
Proceeds on that assumption, that's right.
I think it's put against you, though, that there's no such thing as mere silence. Silence is contextual. So in this circumstance, you've got a buyer and a seller standing in front of the painting, discussing its rich history as an original painting. Now, if we knew that there was a copy, and leave aside the point that's made by my brother, leave aside the point as to whether he did or he didn't know there was a copy. If you acknowledge there was a copy, would it not be the context that gives rise to the duty to disclose? And
Your Honour, the duty has to be a legal one, such as in a fiduciary relationship where the party is required to disclose all material facts to the other party, and there is no legal relationship that would require that between a buyer and seller, which is what we have here.
I don't know if the fiduciary obligation would give rise to an obligation to disclose. It would be depend on the nature of the fiduciary duties, as the High Court says in hospital products, that would be attached to that term of fiduciary in that particular context. But an obligation to disclose a fact, the law would recognise an obligation to disclose if you knew that it was in fact a copy. Would you accept that?
Yep.
Representation.
As the law is stated in Bennett+Co, is only when there is a legal obligation, and fiduciary relationships were mentioned in that case, as in the situation where the facts would then have to be disclosed.
Well, that was a decision quoted by Sir Edmund Bartley, sitting as he then was as a justice of the court, already decided 2 centuries ago. The High Court's moved on from there as to what constitutes a fiduciary relationship. But the point I'm making to you is, even if we accept that a fiduciary relationship is an example of a situation giving rise to an obligation of disclosure, the factual circumstance can give rise. There isn't mere silence, there's silence in a context, isn't there? And I think that's the
Your Honour,
Tucker's going to put against you. I wanted to hear your answer to that.
Your Honour, this was my second proposition, that Milan did not intend to induce John with this silence, as misrepresentation requires an intentional inducement, and Milan's silence to this fact did not and was not intended to induce John.
Well, you can. I don't know if intention is necessary. You have a sit in the Northeast Salt Company distinction between innocent misrepresentation and fraudulent misrepresentation. Fraudulent is knowing it, innocent is careless or negligent. You could carelessly have not known. So I don't know if intention to mislead is a necessary element.
Your Honour, the respondent has, in their written submissions, paragraph 1.1, noted that there is a need for intention and an actual inducement, as we put in agreement with the respondent.
I've been going beyond respondents. It was taking you away from your submissions. I apologise. Go back to them if you wish.
Considering the second proposition, Milan had no reason to attempt to induce John into the contract, as it can reasonably be said that John had already made up his mind to purchase the Highland painting. Before Milan was even born, John had been attempting on many occasions to purchase the paintings from Milan's father. Following Milan's father's death, John continued to attempt to buy paintings from Milan. Milan had no reason to attempt to induce John into the contract, given that John was already so determined to purchase the painting. To say that this balance induced John would mean that if Milan had revealed the fact, it would have had a negative impact on John's desire to enter into the contract. The appellant submits that the revelation of the fact would appear insignificant and would not reasonably have made an impact on someone who has set their mind on purchasing this painting for so many years. Turning now to our second submission, John validly accepted the Studenica painting contract in his personal capacity, and extrinsic evidence is admissible to demonstrate this. Considering the first two propositions, John was not acting on behalf of Salisbury Galleries in a pre-registration contract situation. In the case of Harvey Goodwin and Rose, which dealt with pre-registration contracts, Justice Stark stated the law in the area. Quoting the English case of Kellner and Baxter, His Honour stated, "A company cannot, by adoption or modification, obtain the benefit of a contract purporting to be made on its behalf before the company came into existence." Salisbury Galleries was incorporated on the 6th of April 2018, which is after the offer and acceptance of the Studenica painting contract. Milan sent the offer to John on March 27th, and whether this court accepts that acceptance occurred on the 3rd of April when the email was sent, or on the 5th when it was received, it is still before the date that incorporation occurred. The respondent argued at paragraph 2.3 to 2.4 of their written submissions that there was a mistaken belief here as to whether Salisbury Galleries had been incorporated, and that this would allow John to accept on behalf of the company despite incorporation not occurring. The appellant submits that there has been no mistaken belief here by either party. Paragraph 17 of the facts tells us that John knew the company was not incorporated when he sent the email of acceptance to Milan. As for Milan, the only knowledge he had of the corporation was from the discussions in early March, where John only mentioned once that he was thinking about transferring the gallery to a corporate entity. Therefore, the respondent's claim at paragraph 2.4 that Milan believed Salisbury Galleries had been incorporated was correct. Considering the second proposition, extrinsic evidence is admissible here to identify John as the party to the contract in a personal capacity. As there is ambiguity as to whether John entered in a personal capacity or attempted to enter on behalf of Salisbury Galleries, the Codelph principle applies to allow the use of extrinsic evidence. The case of Abram and Lady Jennings demonstrates an application of the Codelph principle in a situation similar to ours. The question in that case was whether Mr. Abram entered into the contract in a personal capacity or as director of his company. This amounted to ambiguity under the Codelph principle, so extrinsic evidence was used, and it was found that Abram entered in a personal capacity. Justice Bennett+Co, with the other two justices agreeing, looked at the framework of facts within which the contract came into existence. By looking at the discussions between the parties prior to the contract, it was thought that Mr. Abram was entering personal capacity. Further, Justice Bennett stated there would be nothing surprising in finding that Mr. Abram was party to the contract. This was because there was no cogent evidence as to why Mr. Abram wouldn't be the party to the contract. The framework of facts in our case demonstrates that John was acting in a personal capacity. It was only discussed now between Milan and John that John was thinking about transferring the gallery to a corporate entity. As far as Milan was aware, he was making an offer to John personally. Both parties pressed prior to the offer that Milan was free to make an offer to John with no mention of the Salisbury Galleries Corporation. Further, the contract between the parties for the Highlander painting had almost identical terms and was signed by John in a personal capacity. Therefore, it was reasonable for Milan to assume that the Studenica painting was also being accepted by John in a personal capacity. This extrinsic evidence outweighs the fact that John used an email for acceptance that included the name of Salisbury Gallery. It is for these reasons that the appellant admits that John did not validly rescind the Highland Art Painting contract on the basis of misrepresentation, and that John did accept the student painting contract in a personal capacity, as demonstrated by extrinsic evidence. As such, both these contracts should be enforced. May it please the Court.
Thank you, Mr. Angelo. Ms. Tucker, if you just give us a moment, please. Is there a microphone that needs to be muted somewhere? Or is there a small buzzing noise on your end, Ms. Tucker?
Pardon, Your Honour?
There is a background buzzing noise that's audible here. Is that, I was asking, is that audible on your end of the transmission?
Yes, Your Honour.
I think someone may have a microphone still on it. Please could you address that? Thank you. Take it away, Ms. Tucker. Please start.
May it please the Court. Your Honours, I will be addressing the second ground of appeal as well as the second counterclaim, as outlined on the second last page of the Statement of Agreed Facts. Your Honours, we make three key submissions this evening. First, that Mr. Constable validly rescinded the contract between himself and the appellant to purchase the Highland painting. Second, that Mr. Constable did not accept the appellant's offer to purchase the Studenica painting in his personal capacity. And finally, that extrinsic evidence was not admissible for the purposes of identifying Mr. Constable as a party to the contract. Your Honours, ground concerns the contract for the purchase of the Highland painting, while our second and third grounds concern the contract for the purchase of the Studenica painting. For this reason, we must establish all three grounds successfully for Mr. Constable to be free of any contractual liabilities. I will also point out, Your Honour, that these grounds are in the alternative to those raised by my learned senior. That takes me to the first submission, Your Honours, which is that Mr. Constable validly rescinded the contract to purchase the Highland painting as a result of the appellant's misrepresentation. This can be found at paragraph 1.1 of our written submissions. Your Honours, to demonstrate misrepresentation, a party must satisfy four elements. A false statement must be made. It must be a factual statement. The statement must be addressed to the person misled. And the statement must be intended to induce and actually induce the contract. If I could refer Your Honours to paragraph 100 of the Statement of Agreed Facts, we can see at first instance that the learned trial judge did find Mr. Constable's rescission valid on the grounds of misrepresentation. And at paragraphs 2 and 4 of the appellant's written submissions, my learned friend only disputes the first and final elements of misrepresentation, that is, that a false statement was made and that the appellant intended and did in fact induce Mr. Constable into buying the painting. We will therefore only address these two elements. Looking at the first element, the existence of a false statement of fact. Your Honours, our position is that the appellant's failure to inform Mr. Constable of the existence of the duplicate paintings and the fact that the Highland painting was in fact a copy constitutes a misrepresentation by omission. We do recognise that there is generally no duty to disclose in a seller-purchaser relationship. But, Your Honours, if I could refer you to the case of Demagogue Proprietary Limited and Romansky, where Chief Justice Black explained there is no such thing as mere silence. The significance of silence must be considered in the context in which it occurs. The question is simply whether, having regard to all the relevant circumstances, there has been conduct that is misleading or deceptive or likely to mislead or deceive.
As long as the Chief Justice was deciding Demagogue and Romansky was an application of what was then Section 52 of the Trade Practices Act, corporation and trade or commerce shall not engage in conduct that's misleading or deceptive or likely to mislead or deceive. We know from a long line of authority that intention is not a part of that, but you've said that the fourth element of a misrepresentation is an intention to induce. So how do you apply a trade practices case on silence to this case?
Your Honour, one of the ways in which misleading and deceptive conduct can be demonstrated is through a misrepresentation. And so we rely on Chief Justice Black's statement in that regard. We do not attempt to prove that the conduct was misleading or deceptive in this case, but we emphasise the fact that silence is not in itself determinative and is reliant on its context. And that is the reason that we use that judgment, Your Honour.
And what is the context that you say significantly gives weight to the silence?
Pardon, Your Honour?
What is the context that you say we should look to assess silence?
Your Honour, in this context, we look at the relationship, a long-standing relationship between Mr. Constable and the appellant. The appellant has known Mr. Constable since birth, which was in 1960, Your Honour, and this would suggest a relationship based on a substantial degree of trust and integrity between the two. And in such a relationship, it would be expected that the appellant would disclose information about the duplicate paintings to Mr. Constable. And yet, as we can see at paragraph 18 and 19 of a statement of agreed facts, Mr. Constable was shocked upon learning of the existence of a copy of a Hollander painting. And this does indicate that he was unaware of the existence of this copy, meaning the appellant had not disclosed that the Hollander painting was not one of a kind and that there was a copy out there.
I think there's more shock as I read paragraphs 18 and 19 to learn that he was looking at a copy and not the original. But would not the appellant be right in thinking that Mr. Constable had a relationship with his father? And certainly from 1960 until adulthood, he would be under no obligation. And Constable being an older, mature man who had known about these paintings through dealing with the appellant's father. Well, why would he not believe that Constable would know as much, if not more, than he knew? Why would he then, that relationship of trust and confidence that you point to, why would that impose upon the appellant, the younger of the two men, an obligation to speak under that accord?
Your Honour, I would refer you to paragraph 13 of a statement of agreed facts, where we are told that although Mr. Constable has tried on a number of occasions to purchase the painting from the appellant's father, he was always unsuccessful. And it wasn't until early March 2018, at paragraph 15 of the statement of agreed facts, that these two men have a possible sale of the paintings. And so our submission is that by entering into these discussions, they have extended the relationship to an extent that it would be more expected that this statement would be disclosed, Your Honour. Further, in the case of Krakowski and Eurolex, which was heard by the High Court in 1995, it was found that Eurolex's failure to disclose to the buyer the fact that he had entered into a collateral contract with the tenant of a premises in order to ensure the sale went ahead constituted a misrepresentation in the fact that by only disclosing part of the information, the facts around the sale had been distorted. Similarly, Your Honours, in this case, the discussions between the parties did concern the value of the paintings. At paragraph 15 of the facts, we can see that the Mr. Constable was willing to buy the paintings at an increased price on the understanding that they were more valuable as a pair. And yet in this discussion about value of this pair of paintings, the appellant failed to disclose that there was a second pair of these paintings out there and that these paintings were not in fact one of a kind. And it is common knowledge that paintings that are one of a kind are inherently more valuable.
Well, that's the facts as found by the learned judge, the view of Constable. I don't know if it's an immutable view that two's worth more than the sum of two, the holistic view of it. But there were two originals and two copies. Happened that there was one of each in Belgrade and in Australia, isn't it? There's not two.
Yes, Your Honour.
There's not four original paintings. That's the qualitative difference. But I'm taking you away from your argument. You haven't got. Tell me about paragraph 1.5 of your submission. You develop that for me.
Yes, Your Honour. We do not go so far as to suggest that the appellant was fraudulent in his misrepresentation. Instead, we suggest that even if we accept the appellant's argument at its highest and we accept that he was not aware of the existence of his duplicate, then
You have
still
to accept that. There's no finding of a fraudulent or intentional misleading by the learned trial judge. We're an appeal court and you're bound by those findings of facts set out. There is no finding, so you're obliged to accept that it was innocent on the part of the appellant, aren't you?
Yes, Your Honour. Yes, and we find that even where there is innocent misrepresentation, a rescission is still appropriate in these circumstances. If I could refer, Your Honours, to the case of Leaf and International Galleries, which was heard by the House of Lords. Your Honour, in that case, the defendant sold a picture to the plaintiff, and this was sold on the basis that it was painted by a famous artist who was in fact named John Constable. Your Honours, 5 years later, the plaintiff tried to sell the painting and he was informed that it was not in fact painted by Constable, and he sought to rescind on that contract. The court held that the plaintiff had had ample opportunity to examine the painting in the first few days after he bought it. Although the contention in that case was around the period of time that had been left between accepting the painting and wishing to rescind on the contract, the court did express obiter that had the plaintiff sought to exercise the rescission in a more reasonable time, then he would have been entitled to rescind and it would have been valid, Your Honour. Our position is that in the present case, where Mr. Constable has rescinded prior to even accepting the painting, there should be no issue as to the lawfulness of the rescission. With regard to rescission, Your Honours, there has been no exchange of consideration. Mr. Constable has not affirmed the contract because he has not accepted the painting. There has been no significant lapse of time, and no third parties have been impacted. And for these reasons, we submit that rescission is an adequate and appropriate remedy in this case.
Well, the contract remains wholly executory. The difference in Leaf is that the contract has been fully executed. Money paid, delivery, time elapsed. Here, you rightly point out, money hasn't been paid, delivery hasn't been effected, so it remains wholly executory and falls within what used to be known as the Wilderness 7 and North East Stockcamp case. Before that case was analysed and found not to be authority for what was thought to be this rule, but rescission's available prior in an executory contract for innocent misrepresentation. But the distinction between it being executory and executed, I think, is a valid one in this case. So you don't rely on Seven's case.
No, Your Honour. Further, we are required to demonstrate that the appellant intended to induce and did in fact induce Mr. Constable to buy the painting. I will point out that the appellant has known Mr. Constable his entire life, and he is familiar with Mr. Constable's fascination with these two paintings. Additionally, the appellant knew the history of the paintings, including the fact that copies were made, and yet in the 60 years that they have known each other, the appellant failed to disclose this information to Mr. Constable, despite the fact that it would have interested him greatly. Your Honours, if Mr. Constable had been aware of the existence of the copies, he might have sought to purchase one himself, since his request to buy the paintings by the appellant had been consistently refused. The appellant purposely did not mention the existence of the paintings when discussing them with Mr. Constable. And this subject can be explained.
Where do you get purposefully? Now you're getting back into intention, which I think is not open on the found facts. Which of the found facts do you rely upon? And specifically to say he purposefully didn't tell him.
Your Honour, I apologise. I misspoke. I should not have said purposely. But we do point out that the appellant, in his 60 years of knowing Mr. Constable and knowing his interest in this art, failed to mention the fact that copies existed. And this is rather suspicious, Your Honours, when we take into account the fact at paragraph 17 of the Statement of Agreed Facts that the appellant was in serious need of money, and this is why he offered to sell the paintings in the first place.
That's a bootstrapped argument, Mr. Tucker. You can't ask us to act on something that looks suspicious. It was not found to be fraudulent. It was not found to be intentional. We're bound by those findings of fact, as are you.
Yes, Your Honour.
I think you should move on.
Yes, Your Honour. Your Honour, in the interest of time, I will turn to our second submission this evening, which is that Mr. Constable did not validly accept the appellant's offer to purchase the Studenica painting in his personal capacity, and this can be found at paragraph 2.1 of our written submissions. Your Honours, we do agree with my learned friend for the appellant that Mr. Constable accepted the appellant's offer to purchase Studenica before his company, Salisbury Galleries, was incorporated. However, this alone does not mean that Mr. Constable accepted the contract in his personal capacity. I will point out, to begin with, Your Honours, that we are told that the Corporations Act does not apply to the present case. Unfortunately, that means we cannot rely on Section 131 of the Act to ascertain whether this is a legitimate pre-incorporation contract, and we must instead turn to the common law. But Your Honours, my learned friend for the appellant has construed the common law position on pre-incorporation contracts far too broadly, and she has overlooked the important nuances of the case law. In the High Court case of Black and Smallwood, there was a contract between a contractor and two directors of a soon-to-be incorporated company. The parties were mistakenly under the belief that at the time of signing the contract, the company had already been incorporated. The High Court found that the contractor could not enforce the contract against the two directors in their personal capacity because that was not what the parties had intended. Ultimately, the court reasoned that the question of whether a promoter or agent of a soon-to-be incorporated company is personally liable for the contract ultimately depends on the intention of the parties as expressed in the terms of the contract. Your Honours, naturally, where both parties are aware that the corporation does not yet exist, then it is presumed that the parties intended to bind the individual promoters of the corporation, because if this was not the case, then there would be no way of effectively binding the parties in this contract. However, where a contracting party mistakenly believes that the company does already exist at the time of corporation, then it is presumed that the parties intended to make a contract with the company alone and not to bind the promoters and agents of that company. This approach, taken in Black and Smallwood, has been applied in a number of subsequent cases, Your Honour, including the case of Newborn and Sensolid, which was heard by the English Court of Appeal. In this case, Chief Justice Lord Goddard observed that the decision in Kellner and Baxter, which my learned friend referred to, does not mean that every time an alleged company attempts to contract, the person acting for the company is personally liable. In other words, Kellner and Baxter does not create an overarching doctrine that pre-incorporation contracts can never exist and bind the corporation alone.
But I think what's put against you is Hayden Stark's judgment in Dudley, which as a High Court binds us, though what you point out of the subsequent decision of the High Court in Black and Smallwood is the nuance. So leaving aside the English authorities, which of course we appreciate and read with interest, don't bind us in a persuasive or are merely persuasive to the extent that they express what could be the law in Australia. We've long since diverged from England in what is the law. But go back to Black and Smallwood and apply Black and Smallwood, if you could, to the facts of this case. Why, there's no finding, as I read the findings of fact by the learned trial judge, that Constable believed his company had been incorporated at the time he used the email address.
That's correct, Your Honour. However, our position is that only one of these parties needs to be under this impression. Ultimately, the question comes back to the intentions of the parties. Now, Mr. Constable,
That has the objective theory of contract in Australia means that we look to discern the intention from the objective facts, not the subjective thoughts held in the bosom of the contracting party. So,
yes, Your Honour.
what are the objective facts you point to?
Your Honour, in this case, the first objective fact I would point you to is the fact that Mr. Constable accepted the second offer from the appellant with his company email, Salisbury Galleries, rather than his personal email.
I'm sorry, Ms. Twain?
Pardon, Your Honour?
I just heard another voice and I wondered what that was.
Apologies, there's just 1 minute remaining.
All right, extension of time for you as well, Ms. Tucker. Please continue.
Thank you, Your Honour. In this case, Mr. Constable has signed the email of acceptance to the second offer from the appellant with his company email, Salisbury Galleries, and this indicates his intention to bind his company rather than himself personally. Additionally, there is nothing to indicate that the appellant knew the company had not yet been incorporated. The appellant has received this acceptance from the Salisbury Galleries email address. He is not aware that the company has not yet been incorporated and will not be incorporated until the 6th of April. Your Honours, additionally, in the cases referred to by my learned friend, including Dudley, the contract contained a clause referring to the company as the proposed company, and this indicates that the company has not yet been incorporated, which allows for that intention to be inferred that they intended to bind the agents of the company instead. In this case, there has been no indication that this is the proposed Salisbury Galleries. Rather, it is simply signed and accepted by Salisbury Galleries. And so it would be reasonable to infer from that the appellant has intended to contract with Salisbury Galleries and Mr. Constable has intended to contract as Salisbury Galleries. And because of this mutual intention,
The logic fails here. Milan offers to sell Udankia as a letter addressed to Constable. The acceptance is the first time the email address salisburygalleries.com is used. So he doesn't make an offer to the company, he makes it to an individual, to Constable. That's not one of the key objective factors in some level that we need to consider.
that's correct, Your Honour. And unfortunately, we do not have the wording of the offer specifically or of the acceptance in the statement of agreed facts. So it is difficult to ascertain the actual terms of the contract. However, we do know from paragraph 16 of a statement of agreed facts, or rather 15, that Mr. Constable had already mentioned in these negotiations that he was intending to incorporate his company.
Right. Perhaps you could, in the interest of time, just deal briefly with your third ground, please.
Yes, Your Honour. Our position in respect to the third ground is that the evidence rule applies and that extrinsic evidence may only be admissible for the purposes of ascertaining the identities of the parties where there is ambiguity in a contract. And this is the case even in respect of pre-incorporation contracts. Our position is that there is no ambiguity with respect to the parties in the present case. If I can refer Your Honours to paragraph 3.2 of our written submissions, where we refer to the case of Newborn and Sensoled, where they held that writing the contract on the company's note paper clearly intended to involve the company alone, and there was no ambiguity there, even though the individual agent had signed alongside the contract. And our position in the present case is that this acceptance came from the Salisbury Galleries company email address. And despite the fact that John Constable's name is accompanied alongside that company name, our position remains that that is not sufficient to create ambiguity in the present case. And so there is no need to refer to extrinsic evidence, Your Honours.
Thank you.
If has no further questions, that concludes my submissions. We respectfully request that this court adjudge and declare that the contract with respect to Helinda was validly rescinded by Mr. Constable, and that Mr. Constable did not validly accept his second contract for the Studenica painting in his own personal capacity. May it please the court.
Thank you, Mr. Thank you to the 4 contestants. Where to from here?
Well, thank you to you two over at Bennett+Co, as well as the contestants. From my perspective, it seemed like a very well fought and well argued moot. From now on, I'd ask you, Marston and Nathan, if you need any time at all to make any adjustments to the score sheets, write down any feedback. I think if it's okay, I appreciate that it might take some time, and I also need to double check over a few things. So I think we'll probably end the live stream at this point, and then if you can make sure that the raw scores are transmitted to me as soon as possible, I will notify our marketing team as well as the competitors, and we'll have the results published online shortly.
Can I just congratulate each of the contestants for their advocacy? I thought generally, across the board, it was a good, if not high standard. One of the greatest lessons to learn as an advocate is how to listen. And so the difference between an advocate and a newsreader is you don't read out your arguments, you listen and you develop your arguments, and each of you attempted that in a constructive fashion. The other thing across the board, if I can just point out, dealing with this, we weren't dealing with agreed facts. We were dealing with a summary of facts as found by a trial judge. That's each of you referred to them as agreed facts, and they're not presented in the problem as agreed facts. They're presented as a summary of the findings of fact in first instance. That is, we think, is a technical point, and because all 4 of you did have the same technical flaw, it neutralises itself out across the line. So don't clasp your hand to your brow and go, "Oh my God." And that's a key point. That's just an observation that when you're dealing in an appellate circumstance, the role of the appellate court, as the High Court indicated, Fox and Percy, is that it's only in the rarest circumstance that you can go behind a finding of fact. So you look to the findings of fact, and you've got to craft your argument within those findings of fact, or a persuasive argument as to why the finding of fact was wrong. It was against the weight of evidence or unsupported by evidence. But generally, you dealt with questions well. They didn't throw you off too much of what you were intending to say. The part of our assessment is to see how you cope with irrelevant questions and how you cope with interruptions from the bench. So that was why we felt it necessary to interrupt you. And trust me, that happens in appeal courts generally. So thank you very much, and congratulations on all of you.
Right.
Thank you.
Thank you so much.
Thank you.
Thank you.
Did anyone have any further questions for Marston and Nathan?
No.
For you. Fantastic. I'll just close off the live stream.
Stay safe, please.